so quiet.
Why?
Scary. Let's begin. Dear students, дорогі студенти, сьогодні у нас унікальна можливість в рамках нашого проєкту KMU VOICES послухати лекцію відомого професора з Ягелонського університету, який спеціалізується на медичному праві. So today we have a unique opportunity in the framework of the project KMU VOICES. We have an opportunity to listen to the lecture of a very well-known professor from Jagiellonian University, who is specialized in health law. And this cooperation with European Association of Health Law is really important for our university. Actually, we are the first and only university in Ukraine which signed an official agreement with this association, and this is the leading association in health law in Europe. The members of this association throughout year that will come, an academic year, will give lectures to our students, to experts in health law from Ukraine. We will simultaneously translate into Ukrainian, and this unique international content will be available for our community in order for us to be stronger. Наша співпраця з Європейською асоціацією медичного права, співпраця нашого університету з цією асоціацією, вона є унікальна, тому що ми є єдиним університетом в Україні і першим, хто офіційно підписав умову з цією асоціацією. І завдяки цій умові наші студенти, по-перше, звичайно, ми завжди думаємо про вас, по-перше, ви в пріоритеті, а також всі фахівці у сфері медичного права в Україні будуть мати кожного місяця можливість прослухати лекцію від лідерів думок чи думки у сфері медичного права, і, звичайно, використовувати ці знання на практиці в Україні. Ну і це, звичайно, дозволить нам, українцям, бути ще сильнішими, ще розумнішими. І ось у нас ми починаємо таку ось важливу співпрацю, яка була започаткована президентом цієї асоціації, професором Стівеном Лірман з Бельгії. І сьогодні маємо можливість послухати лекцію Томаша Сроки в сфері медичних гарантій або таких прав у сфері охорони здоров'я. І, звичайно, що ці права в сфері охорони здоров'я, вони дуже-дуже відрізняються у всьому світі. І тому ми сьогодні зможемо послухати, які є найкращі практики у Європі. Тому ми починаємо ось. So we are starting this cooperation, very valuable cooperation with the European Association of Health Law, with the lecture of Professor Tomasz Sroka from Jagiellonian University. And it's dedicated to fundamental health rights which are really, really different in between countries. Today we will have opportunity to listen what are the best practices in international health law. So before we begin, by the way, do you know how old is Jagiellonian University? Just recently, I think some students were in Museum of Anatomy last week. Наскільки ну, старий, скільки років Ягеллонському університету, хто знає? Ніхто не знає, ну, guesses, які здогадки? 200? No, 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 no. No, no. О, ну ти не піддивився, чи був на цьому, в музеї історії, в музеї анатомії. He was just recently in museum. Okay, this year, Jagiellonian University, which is one of the oldest in the world, celebrates 661st birthday. So let's congratulate with 661st birthday this university. Mr. Professor, would you mind to tell a bit about yourself, and the stage is yours. Okay, enjoy this content.
Water is here. Thank you very much. Thank you very much for the invitation and possibility to say a few words to you during this summer camp. As was mentioned before, I work at the Jagiellonian University at the Department of Bioethics and Medical Law, and I have courses in medical law or health law with law students and medicine students at this university. And from a couple of weeks, I am also the member of the board of the European Association of Health Law, which has the cooperation with your university about the future lectures in relation to health law. So I'm starting this project probably, but for sure you will have much better lectures during the next academic year than this one. Topic of the presentation is about the contemporary trends in the protection of the fundamental rights in health law. I'm not a specialist in the legal regulation in Ukraine in the area of the health law, and because of this, I cannot present you in details the legal rules of providing medical services and protection of particular rights and freedoms under the Ukrainian law. Also, you will not probably interested so in Polish, our domestic regulation in this area, but we have some very important European or international background in the area of health law. This is the European Convention on Human Rights and the Oviedo Convention about biomedicine, which is the basis for the creation of the rules of delivering medical services in Europe. And because of this, I think it is good to know what is the standard of the protection of rights and freedoms, mainly of patients in Europe, from the legal point of view, in the action of delivering medical services, where are the main still problems in this area, and where I think we will have in the near future the necessity of the development of the new standard, because we are at the beginning of the process of changing of the process of delivering medical services, also because of the access of the new technologies, the huge access to processing of data using of artificial intelligence and other algorithms in medicines. This rise new questions about the protection of the fundamental rights, and I will try to show you where, in my opinion, there should be or could be some necessities in the development of the protection of fundamental rights. So this is the topic of this presentation. Where we are, we stand, maybe I will start with the short presentation. What is the current status of the protection of fundamental rights in Europe, where we are in the development of the legal rules in the health law, medical law, and why, in my opinion, the picture of the protection of fundamental rights, it cannot be assessed as a good or well developed. Firstly, for sure, in Europe, we have developed a minimum standard for the protection of human rights in the context of basic patients' rights, including mainly the right to autonomy and self-determination, so the consent for medical intervention, the right to information, and the right to medical confidentiality, and connected with this right to protection and the access to medical records. And this basic standard, how to deal with the autonomy of patients, who should give the consent for medical treatment, who should have the access to the information or medical records of patients, in which way we should protect the confidentiality of data concerning patients, is nowadays codified in the Oviedo Convention, and this is the basic European act in relation to health law. You see on the screen a group of provisions from the Oviedo Convention related to autonomy, right to information, confidentiality. I will not present you in detail, analyze this provision. This is only to mention this is the part of the health law which is quite good established in the European region. Secondly, we have a huge development of the jurisprudence of the European Court on Human Rights in relation to fundamental duties of public authorities or states in relation to the protection of life or health of patients, including the development of substantive and procedural duties of the state. What does it mean? Firstly, from many, many years, the European Court on Human Rights, during the evaluation of the possible violation of right to protect life or right to protect private life in relation to health in European countries, developed the positive obligations of states to guarantee the proper level of the protection of life and health of patients during the course of delivering of medical services. And there are repeated theses made by the court that the public authorities in each European state has the obligation to adopt some appropriate measures, factual or legal measures, for the protection of their patients' lives and health. And in the jurisprudence of the European Court on Human Rights, when there is a case of the death of the patient, or there is a case of the huge or important damage or injury of the patient, the European Court on Human Rights analyze this particular case from the perspective whether or not the public authority introduce appropriate measures to protect the lives or health of the patient, and this death of a patient or injury of the patient was only the result of the accident, or maybe whether or not there was the violation of these duties of the state, and then it is possible to declare by the court that was the violation of the European Convention on Human Rights. And of course, it is not possible to present you in details what kind of specific detailed appropriate measures should be introduced by each state in Europe to guarantee the proper level of the protection of life and health of patients in hospital or other medical entities. But after the analysis case by case of the cases before the European Court on Human Rights, you can find kind of direction what should be the proper way to protect the fundamental rights of persons during the hospitalization and other form of medical treatment. There is also huge development in the procedural aspect of these rights. This procedural aspect contains necessity of establish the cause of death of patients during the course of treatment, and when it is necessary from the perspective of the protection of the life or health of patients, to assess the responsibility of medical professionals. And this procedure of the determination of the cause of death of patients, the procedure of the determination, the reason for the injury of the patient, and then the obligation to assess the responsibility of medical professional, or the procedure for receiving the compensation for damages by patients is recognized in the European in Europe as one of the most important fundamental procedural aspect of the protection of fundamental rights. Of course, this procedural aspect, the main purpose of this procedural aspect is not to make medical professionals responsible for medical errors committed during the process of treatment of patients, but rather to create the procedure in which it will be possible to determine the cause of the damage or the cause of the death of the patient during the treatment, to avoid this similar or this kind of mistakes in the future. So this is the general picture, but in this picture we still have some problems with the protection of fundamental rights in Europe. What kind of problems? Firstly, in my opinion, there's a still continuing lack of resolution of fundamental or baseline issues in medical law. For example, unclear status and standard of the protection of human rights in relation to embryos or even fetuses or unborn children. When you look into the jurisprudence of the European Court on Human Rights, the result of the assessment, what is the legal status of embryos, fetuses, or unborn children, is very, very unclear. On the one hand, you can find very clear statements in some judgments, Vaughan against France, or, for example, Evans against the United Kingdom, that embryos or fetuses do not have a right to life within the meaning of the European Convention of Human Rights, that embryos, fetuses, unborn children are not treated as persons who have rights in the meaning of the protection of fundamental rights. This is one perspective. On the other hand, in the jurisprudence of the same court, you can find judgments where, in opposition to this perspective, there are statements, for example, that embryos or fetuses cannot be reduced to possessions from the perspective of the law. And we have an unclear situation how to treat embryos, fetuses, and unborn children in the European context. Because on the one hand, there are not persons who have rights. On the other hand, these are no possessions and cannot be reduced to any kind of possessions. And the legal status is very, very unclear. Because of this, very often the European Court on Human Rights repeated in judgments that the assessment of the legal status of embryos, fetuses, and so on is in the wide margin of the appreciation of the European states, and because of this, we have huge differences between European countries, how to deal, how to treat, how to assess from the legal point of view the position of the embryo, the position of the fetus. And because of this, we have very important differences as a consequence of this. For example, in relation to legal assessments, some medical procedures, including, for example, in vitro fertilization treatment of or medical assisted procreation, or the possibility of providing medical experiments using embryos. There are states in Europe, for example, Poland, where this kind of activities are forbidden because we are quite close to the treatment of the embryos or the fetuses as human beings who have fundamental rights in relation to the Polish constitution. But on the other hand, when you look at the legislation in the United Kingdom, for example, there are no problems with the providing medical experiments using embryos because in the UK, embryos are not treated as a subject of any fundamental rights. It's rather kind of possession using in the medical experiment. Very different approach. Secondly, I started this presentation with showing you some provisions from the Oviedo Convention related to the basic patient's rights, right to consent, information, confidentiality, and so on and so on. But you should know that we have in Europe quite limited effectiveness of the Oviedo Convention and its protocols, because this convention still is ratified by a small number of the European countries, and this number has not changed for many, many years. And what is more important, it is only one opinion, interpretation of the European of the Oviedo Convention made by the European Court on Human Rights related to right to consent. And because of this, on the one hand, we have the Oviedo Convention with the regulation of the basic patients' rights in Europe, but on the other hand, a small number of states ratified this convention, and because of this, in only a small group of European countries, this convention is a part of commonly binding law. Even Poland signed the Oviedo Convention, but not ratified it, and because of this, this convention is not part of our commonly binding law. Thirdly, when you look into the jurisprudence of the European Court on Human Rights in relation to medical law or health law cases, you can realize that there is a kind of stagnation in the jurisprudence, because the same problems in relation to patients' rights are examined by the court, and there are no new issues or problems in biology and medicine which have been solved by the court. Of course, I am aware that the activity of the European Court on Human Rights depends on the subject matter of cases brought. Nonetheless, the subject of these cases shows where contemporary threats to human rights in medical law are perceived in the individual or particular states in Europe and require the European Court on Human Rights intervention. And probably we don't see the evaluation of the legal system in relation to biology and medicine, and the necessity to solve some other new problems also connected with the new technologies. What else? From the perspective of the protection of the fundamental rights in Europe, we have also basic standard for the protection of human dignity in healthcare, primarily in terms of the protection against inhuman treatment in the medicine. And you can find in the jurisprudence of the European Court on Human Rights a lot of cases with the description when the treatment of the patient in a particular way can be assessed from the legal point of view as inhuman or degrading treatment. And these cases involved a lot of different situations. Policy versus Slovakia, the problem of receiving the consent for very important for the young woman intervention, this is cesarean section, and the possibility of other services connected with this in an improper way. We have the jurisprudence of the court related to the status of persons who are deprived liberty and the obligation of public authorities to guarantee them the access to a diagnosis or medical treatment, and lack of the access to the medical treatment of diagnosis for persons deprived liberty is assessed as inhuman treatment from the perspective of the fundamental rights. This includes not also the situation of patients, of persons in prisons or other criminal entities, but also patients, for example, in psychiatric hospitals or social care homes, who in the perspective of the jurisprudence of the court, are treated as persons deprived liberty. And there is a lot of judgment presented that when a person is under the responsibility and control of the state because is deprived liberty, it is the obligation of the public authority to guarantee this person the access to the proper and timely medical treatment or diagnosis, and lack of this possibility is qualified as an inhuman treatment. We have also some cases in relation mainly to abortion and the access to abortion, termination of pregnancy, both of these cases against Poland, where lack of the timely access to genetic diagnosis of the fetus, or the cumulation of the violation of patients' rights during the providing of the termination of pregnancy, was not only qualified as a violation of the right to protect private life, for example, but also as inhuman or degrading treatment in medicine. Thirdly, in Europe, we created standard for solving only certain selected conflict situations in health law or in medicine or in healthcare in more general, from the point of view of the respect for human rights, also in codified form. But so I think, for example, about transplantations or medical experiments, because we have regulations in this area in the Oviedo Convention. But still in Europe, it is still marginal development of the human rights protection standard in the field of, for example, health data protection. And I do not think about the issue of medical confidentiality, because we have some cases or rules related to the obligation on confidentiality and some exceptions from the obligation of confidentiality when medical professionals can provide some information about patients to other persons or entities. But about various situations or cases of data processing for public purposes, with some including some situations related to criminal or judicial proceedings. On the other hand, maybe you probably know that in the European Union we have a new regulation related to the processing of health data. This is the regulation which established the European health data space with the rules of primary and secondary use of health data of patients for not only public purposes, but also for scientific purposes. And although the European Union proposed to European countries very detailed regulation how to deal with health data of patients, also about data concerning determinants of health of patients, we still don't have the solutions for the basic issues related to the protection of the privacy of patients in relation to their data. For example, we don't know from the perspective of the fundamental rights, and there is no consensus in Europe, what is the legal status of the health data. Whether health data are only of private interests of patients, or whether in the contemporary society, taking into account that it is not possible to deliver medical services, to create new solutions for medicine without processing of data, whether medical data should be treated as a common good or common interest, and patients don't have the right to decide solely about using or not their data in the processing of delivering medical services. What else? From the perspective of the fundamental rights, in Europe, mainly because of the jurisprudence of the European Court on Human Rights, we created a kind of direction for interpretation and application of human rights for new challenging situations in healthcare, not yet regulated by international law, and very often not yet regulated in domestic regulations in Europe. For example, the problem of persistent therapy and the possibility of withdrawal of treatment in a situation called persistent therapy, and the possibility of withdrawal artificial nutrition or hydration of the patient in the last stage of life. We don't have any commonly binding legal regulations how to deal in a situation of persistent therapy. Even in Poland, in our domestic law, we don't have any provision how to deal with patients in a situation of persistent therapy. But when you look into the jurisprudence of the European Court on Human Rights, cases Lambert versus France, case Charles Gard against the United Kingdom, you can find the general description of the standard of processing by medical professionals in the persistent therapy. So, in a general way, wide margin of appreciation and regulation of this kind of area. It is not forbidden from the human rights law to accept the possibility of withdrawal treatment or withdrawal artificial nutrition or hydration of or withdrawal life-sustaining treatment for patients, but there must be some guarantees to assess each particular situation. These guarantees are described, for example, in this case, Lambert versus France. So the necessity to take into account the previously expressed wishes by patients, the necessity to evaluate the opinion of members of family of the patient or close relatives, the obligation to take into account the opinion of medical experts, and at the end of the whole procedure, when there is a conflict, for example, between medical professionals and members of family, or we don't know what was the previously expressed wishes by patient, there should be access to the proceedings before the court, and the court should have the possibility to decide about withdrawal or not this kind of treatment, taking into account the best interest of the patient. Then gender reassignment and treatment by the law, the whole procedures of gender reassignment, which are sometimes connected with the causing of the huge bodily harm from the perspective of the legal system, when someone is required, for example, to undergo the sterilization procedure. In Poland, we don't have any regulation concerning how to provide the whole procedure of the gender reassignment from the legal point of view. Even we don't have any direct procedure how to treat the patients after the gender reassignment procedure, and how to make, for example, the changes about the gender of the persons in the civil registers. On the other hand, you can find in the judgments of the European Court on Human Rights, starting from this case, Christine Goodwin versus the United Kingdom, that in 21st century, the right of transsexuals to personal development and to physical and moral security in the full sense enjoyed by others in society cannot be regarded as a matter of controversy, and because of this, these persons should have the access to recognize by the legal system system as persons with new gender identity. On the other hand, there are two kinds of practices in Europe with the procedure of the gender reassignment, taking into account both aspects of this procedure, that is medical and legal part. There are some countries, for example, where firstly, a patient is obliged to complete the whole medical procedure of gender reassignment, including the necessity of surgery of sterilization, and after the complete and after at the end of this whole procedure, it is possible to make the legal steps towards changing the legal status in the civil registers. On the other hand, there are some states in Europe when the situation is different. Firstly, patients are obliged to complete the legal procedure and change the gender identity in the civil registers. And after changing the sex in the civil registers, it is possible to start and complete the whole medical procedure of gender reassignment. But there are cases very often in Europe when, for example, patients would like to make the gender reassignment procedure, but without necessity to complete the whole procedure, without necessity to undergo the sterilization procedures. And there is a question whether or not the legal system can require from them to complete the whole medical procedure of the gender reassignment. We don't have any legal rules in Poland in that area, for example. On the other hand, you can find in the judgments of the European Court on Human Rights, for example, in the case AP Grasson and Nicole against France, that it is the violation of the fundamental rights to force the persons during the gender reassignment procedure undergone sterilization surgery or other kinds of this kind of medical interventions. And the legal systems in the European countries should guarantee the access to the gender reassignment procedure with the possibility of changing of the status in the civil status records without necessity of the completion of this procedure, without necessity of undergoing the sterilization procedures. Yeah? So this is the development in this area. Thirdly, we have a lot of cases in the European Court on Human Rights presented nowadays the approach to the termination of pregnancy and abortion and how to treat the abortion from the perspective of human rights. Of course, we are in Poland, and from a couple of years we have a huge public discussion about termination of pregnancy and abortion in Poland. And very often in this public debate, it is repeated that the access to abortion is a part of the human rights, or strongly that one of the human rights is the right to abortion. And of course, in some international documents, the right to abortion is declared as one of the human rights. But when you look into the jurisprudence of the European Court on Human Rights under the European Convention on Human Rights, the approach of the court is quite different. Article 8 of the Convention, so the right to protect private life, this thesis is repeated every time in every single judgment of the court, not only in this ABC against Ireland, cannot be interpreted as conferring a right to abortion. The European Convention on Human Rights is not interpreted as containing right to abortion as a human right. But on the other hand, the court underlined many times that the problem of the termination of pregnancy or abortion must be taken into account when we think about the protection of health or well-being of women. And because of this, the mechanism of the termination of pregnancy or the procedure of abortion should be treated as a kind of solution for a situation of the danger for health or well-being of women. Sometimes when there is a danger for the life or health or well-being of women, it can be necessary to give the access to the procedure of the termination of pregnancy, because without access of this kind of procedure, it will be not possible to protect these values of women. And because of this, the termination of pregnancy or the abortion under the European Convention on Human Rights is not treated as a human right at all or solely, but rather as a solution or mechanism of the protection of health or well-being of women when there is a danger for these values. And we have also the development of the European Court on Human Rights with the procedure of the access to the termination of pregnancy, also in cases against Poland, where, for example, Policja 1000 versus Poland, where the European Court on Human Rights underlined that there should be kind of procedure of the evaluation of the negative opinion of physicians in relation to whether or not a particular woman could have or not the access to the termination of pregnancy. What else? There is a development in the understanding of the fundamental rights in relation to medical assisted procreation, including in vitro fertilization treatment. However, you should know that in the opinion of the court, because we have still non-consensus in Europe how to deal with the legal status of embryos, gametes, how to deal with the procedure of the in vitro fertilization treatment, European states have a wide margin of appreciation and regulation of this kind of activity. For example, in that perspective, in one case, as H and others, against Austria, the court stated that in the perspective of the European Convention on Human Rights, there is no obligation of European states to guarantee the access to medical assisted procreation. So it is not the duty of the state to give all interested patients the possibility of using of medical assisted procreation treatment. On the other hand, there were some cases presented how to deal, for example, with the access to prenatal genetic diagnosis or some detailed aspects relating to medical assisted procreation. Then something which is quite good known in Ukraine, so surrogate motherhood and the access to the procedure of surrogacy. Also, the European approach to this problem is in that way that we have no consensus in Europe between European countries how to treat or how to deal with the surrogacy. Because of this, there is a wide margin of appreciation of the European countries to accept or ban this kind of practices. But what is very important for the court, because we have the possibility of traveling between countries and to complete the whole procedure abroad and come back to the origin country, there should be some procedure in the domestic countries to recognize the relation between child and parents after the realization of the surrogacy agreement. And there were cases, Menason against France, or advisory opinion of the European Court on Human Rights last year, even the case against Switzerland related to the same-sex couple of parents and the obligation of the recognition of the child parent relationship with the same-sex couple as a consequence of the surrogacy agreement. So this is the area where there are some developments in the protection of fundamental rights in relation to new challenging situations in medical law. But contrary to this view, we are still at the beginning of the development of the human rights standard in relation to the contemporary and urgent problems in the field of medical law, mainly concerning the balancing of private and public interests. For example, vaccination, whether or not there should be the obligation or the duty to be vaccinated, what can be the consequences of refusal the vaccination, and whether or not, for example, after the pandemic of COVID-19, it will be possible it was possible by European countries to introduce the obligation of the vaccination against COVID-19, or, for example, to introduce the ban for practicing of medicine by medical professional without vaccination against COVID-19, and so on and so on. We are at the beginning of the development of this kind of standard. For example, we still don't have any kind of legal rules in Poland relation to this area. Okay, so this is the general description where we are. And now a few words about some selected, projected, or expected directions of human rights development, so where we should go in the area of the health law. Some chosen issues. Firstly, the right to court and the right to access to a court in medical law cases. For decades, in health law and medical law, we have attributed to the courts a key role in health law or medical law. The courts have the role to resolve conflict situations, assessing the lawfulness of the deprivation of liberty of patients, decided, for example, how to deal with the incapacitated persons. Even the European Court on Human Rights underlines that important role of the courts they play in resolving disputing or giving legal guidance in relation to medical treatment. But on the other hand, mainly in Poland, but not only in Poland, we have the progressive erosion of the authority of courts and gradual loss of trust in the courts, particularly in cases involving the personal sphere of individual. For example, I can make quite rhetorical question: how many contemporary adolescentes, teenagers, following the trust and authority of the court and will accept without contesting the court's decision about the direction and the method of treatment if it contradicts the minor's opinion? And it is very difficult situation because we have quite established solution that in a situation of minor patients, also when there is a necessity to receive the consent of the parent and the minor patient, and there is a conflict between them, this conflict should be resolved by the court. But at the end of the whole procedure, with the erosion of the trust to the courts, this minor will not accept the decision made by the court that the parent has the right, and we should go in accordance with the decision of the parent, contrary to the opinion of the minor patient. And we don't have any solutions nowadays for this kind of problems. What is more important, the populism in Europe, the populism in law, and the related crisis of the rule of law, including the judiciary, are also involved in the destruction of the trust to courts. Individuals may have also justified doubts to whether a particular court or a particular judge will adequately protect the fundamental rights in the healthcare system, including right to protect life or health, if the same court or the same judge act against the standard of the protection of the human rights because of the crisis of the rule of law. And we are somewhere at the beginning of the necessity for the answer of the question: what should the standard of the right to accord in medical cases look like today? Whether or not we should still accept that at the end of the whole path of solving the problems in medical or health law, we should have the access to the court, and the court should have the decisive role in solving this problem. Should courts continue to resolve the most serious conflict situations, or maybe we should find another solution? And probably what is maybe the most important nowadays, we are at the beginning of the process how to build the trust and authority in the courts in medical matters, and maybe what is more important, how to build trust and authority of medical professionals in the area of the medicine to guarantee the proper course of the diagnosis or treatment of patients. Then, probably in the near future, we will have the development of the positive obligations of public authorities in biology and medicine, and also in the healthcare system. Traditionally, the positive obligations of state in the area of the protection of human rights, also the right to life or the right to health, have consisted of three types of duties: right to respect, right to protect, and right to fulfill. The right to respect generally means the prohibition of state action that results in the deprivation, in our perspective, of life or of health in the context of the healthcare sector. For example, the prohibition of the destruction nowadays, determinants of health, including environment and climate. And probably you heard that last year we have a huge case before the European Court on Human Rights, trying Klimaseniorini in Schweiz and others against Switzerland concerning the protection of the European society and Swiss society against negative consequences of the destruction of environment and climate change. And there were presented by the European Court on Human Rights some general and also somehow some detailed solutions. What are the duties of the public authorities in the protection of the society against the negative consequences or implications resulted from the change in climate or the destruction of the environment? And because this is one of the determinants of health, and we are still in the establish of the standard of the protection of life and health in relation to other determinants of health, for example, food, nutrition. I think that we will have in the near future the development of the human rights standard, including the jurisprudence of the European Court on Human Rights, beginning from environment or climate cases in relation to the determinants of health. So we will less focus on typical patients' rights related to right to consent, information, access to medical records, but rather in the near future there will be development in Europe, the human rights approach, how to protect interest of patients in relation to determinants of health, starting from the problem of environment and climate cases. Second is right to protect. The right to protect in general is the duty of public authority to take measures to prevent human rights violation by any actor or individual and to mitigate any harm resulting from such violations. In the context of the protection of life and health in relation to healthcare sector, this obligation means that the state must take measures aimed at preventing the emergence of socially unacceptable risks to human life and health or violation of these values as a result of threats posed in the healthcare sector. And in the perspective of the right to protect, I think that three issues will be very important in Europe in the near future. Firstly, this is the problem of the information about risks to health and life. As a general way, a right to protect means a duty of the state to provide individuals with access to essential, relevant, and appropriate information about risks to their health lives, and sometimes even a duty to provide such information proprio motu. So the state must proactively inform individuals of the risk to life or health and not merely create a procedure for individuals to obtain information. And of course, in traditional interpretation or implementation of this right, And in the current functioning of the healthcare system, this right was incorporated in that way that public authorities present general information about the healthcare system, and public authorities rather not proactively provide to citizens the information about healthcare system, the methods of treatment, and so on and so on. This proactive duty nowadays still is mainly shift to healthcare professionals. You, as a future physicians, are merely obliged to present patients all important information, how to deal with this kind of disease, how to treat this kind of disease, how to behave to avoid this kind of disease, and so on and so on. But the COVID-19 pandemic has shown that in order to achieve community-wide effects and combat fake news, I can say, there must be proactively, the public authorities must proactively inform the society about different aspects of the healthcare system, about the organization, financing, standard of current medical knowledge, for example, and so on and so on. And taking into account the advances in new technologies, the possession of large amount of data, the possibility of easy use of the data and the easy access to citizens, and the existence of the information bubbles in the society, we are probably at the beginning of the creation of new duties of public authorities to act proactively in the healthcare sector and to deliver directly to patients some information about organization, financing, and treatment and diagnosis, and so on, and not without shifting of these aspects of information to medical professionals. Secondly, we are probably at the beginning, or we are in the process of, or in kind of trend, I can say, of increasing rationing and standardization of activities in the health system, from the production of goods to provision of services. We would like to have the standard of the procedure established to all aspects of the diagnosis or treatment of the patient. But from the human right perspective, the health system does not allow for full standardization. Healthcare provision is a necessity to take into account some various additional interests which cannot be standardized. For example, ethical issues, subjective expectation of the patients, possibility or sometimes even expectation of taking risky action by medical professionals, the protection of the freedom of practice of medicine by medical professionals. And it is therefore necessary to examine in the near future how far these rationing measures should go. Where are the limits of the standardization of the medicine? Because we cannot limit the activity of the medical professionals to act in accordance with the standardization of all aspects of the medicine. Firstly, we are in the process of concretizing the positive duties of the state. It is no longer a question of the general standard, how to protect human rights in the medicine or in the healthcare system, but a concretization of the specific rules. You can find in the judgments of the European Court on Human Rights related to climate cases the beginning of the process of transformation of the scientific knowledge into the legal obligation of the state. And because of this, in the near future, we will have in Europe kind of trend incorporation of well-established scientific standards into the scope of the duties of public authorities. So it can be said that in the near future, right to protect life or right to protect health will be interpreted in a detailed way in accordance with the necessity of the acting in accordance with the current medical knowledge and commonly accepted scientific approach to protect and treat particular diseases. There will be a kind of standardization, but detailed standardization of the human rights. And the right to fulfill. The right to fulfill means the obligation of the state to take measures to create a situation that enables the full realization and enjoyment of human rights. And in the context of the protection of life and health in the healthcare sector, this obligation implies the need for the state to take measures to improve the state of the healthcare system in order to ensure the fullest possible safety of human life and health. And in that area, for sure, we will have the creation of the positive duties of the state in the field of the protection against new dangers of civilization, for example, gambling and addiction of new technologies, including social media, because we don't have any legal rules how to act with the people who are addicted from gambling or social media, for example, or other new technologies. And this will be in the near future the huge problem. This is a huge problem of the contemporary society. We will have to establish the standard of the protection of life and health in relation to elderly people because of the state of our society. And of course, we are somewhere in the beginning how to deal with the problems related to data. And this is not only the problem of the data security, protection against release the data, the health data to unauthorized person, but it is a more a fundamental issue. What kind of data on health or health determinants can state collect and process, for how long it can be done, and for what purposes, and whether or not individuals should know about this and should have the possibility to make a consent of using their health data by public authorities to different purposes. I mentioned this because, as I said previously, from last year we have in the European Union the new regulation about the European health data space. This regulation creates the mechanism of the secondary use of the data with the obligation of medical entities to give the access also to public authorities to data concerning patients which are processed by medical entities, including hospitals, and the possibility of use this data for public purposes. When you look into the text of the regulation about European health data space, you can find Article 33 about minimum categories of data for secondary use. Minimum. The title of this provision is minimum categories of data which can be made available by medical entities to public authorities for secondary use and some purposes. And when you look into the lists of this minimum category of data, it's not only data from electronic health records of patients, but these are also data about factor impacting on health, including socio-economical, environmental, and behavioral determinants of health. These are data about, for example, human genetic data generated by medical devices and wellness applications, data resulting from the different databases, data concerning administrative data, reimbursement data, and so on and so on. And we are in the European Union in the process of the introduction of the mechanisms where in the near future the public authorities will have the access to the huge amount of data collected by medical entities concerning not only the state of health of the patient, but all determinants of health and all aspects concerning delivering of healthcare services, and the possibility of using of this data for the creation of the politic of the state in the different areas of life. And this regulation is introduced, in my opinion, without proper evaluation and examination. What are the limits of the possibility of using of health data of patients by public authorities in creation of the politic of the state? Whether or not a patient should have the possibility to consent or to know for what purposes my data concerning my determinants of health are used by the state in the creation of the, for example, social policy. So these are new challenges in the near future about concerning protection of human rights. And we will see in which direction our approach to fundamental rights will come in the near future in this area. I think it was so boring that we can end at this point. Okay. Thank you very much. Yeah.
And because I want to take a photo with you, Mr. Tukanevich, okay? Few minutes, wait.